and petitioner would call Crystal Starks.
All right. She's
She's here.
okay.
Well, I can't see interpreters, but I can see Crystal.
Sorry, we're trying to make sure everything works. We can see everything.
Okay.
We can see.
This gentleman out there is, may have trouble seeing, I don't know,
Your Honor, sorry.
in the green shirt. He was raising his hand.
Oh,
He said, no, I'm set.
Oh, okay, good. All right.
thank you. If you can raise your right hand, I have to swear you in first. So, I, and say your name.
My name is Crystal Starks.
Do solemnly swear
I do solemnly swear
to tell the whole truth
to tell the whole truth
and nothing but the truth.
and nothing but the truth.
So,
So help me God.
good morning, Ms. Starks. I just wanted to start with
Good morning.
some background information. So I'm just going to start with, how do you know Ricardo Harris?
We met at RIT, Rochester Institute of the Deaf, where we were both college students.
And what is the nature of your relationship with Mr. Harris?
So we started as friends initially, and then we started dating in the summer of 2010.
And I just wanted to clarify that where you guys met was Rochester Institute of Technology.
Yes, Rochester Institute of Technology in New York.
And you said that you started as friends and you started dating, I'm sorry, you said in 2010?
Yes,
And so were you still dating in 2013?
yes, we still were.
And were you also dating in 2015 at the time of Mr. Harris's trial?
Yes,
And are you still his girlfriend?
yes, I still am.
And I understand that you're deaf. What's your primary form of communication?
My primary form of communication is American Sign Language. Secondary is English.
And what is Mr. Harris's primary form of communication?
He communicates primarily to me in American Sign Language.
And have you been around Mr. Harris when he has been interacting with hearing people?
Yes,
And how does he communicate in that environment?
first he reads lips and uses his voice, but if he doesn't understand, then he'll start a text message.
Um, when you interact with somebody who can hear, do you communicate in a similar way?
No. I don't read lips, or write or text. Okay. The interpreter's gonna clarify. I don't read lips, I either write or text message.
Okay, so I just want to make certain I'm understanding. So you don't read lips, but Mr. Harris does. And then,
No, I don't.
but you will write or text.
Correct.
And he will start by reading lips, but if things deteriorate, then he will change to writing or using text.
Correct.
And in those interactions, how effective is that communication? Do you feel like you're able to get your point across when you're talking?
Yes, mostly it's successful. It's easier with writing or texting.
And do you feel that you are understanding the hearing individual that you're communicating with?
Yes.
Just objection, I'm not sure the relevance of her communication style.
I'm actually trying to establish the foundation between how she's described her communication and how she's describing Mr. Harris's communication. I'm trying to establish the foundation for her witnessing his communication style or communication efficacy.
One moment, sir. But, whether or not he can understand people and people can understand him would be something that she would be totally speculating about because she is not him.
I take it that we're establishing how they communicate, and if we're talking about how he communicates with someone else, then I think she may need to say whether she understands that or not, or knows that or not.
Although, Your Honor, we would certainly object to the extent that she would attempt, or counsel would attempt to elicit through her whether petitioner understands.
I understand it, but we started a preliminary effort to try to establish relationships and understandings and history.
Sure.
And I think it would be helpful for the court for her to be able to tell us what she knows and what she doesn't know. At this point, your objection may be correct.
Perhaps I objected too soon, Your Honor.
I would like for them to be allowed to go ahead and lay a foundation for whatever
I understand, Your Honor. Thank you.
Thank you, Your Honor. Can I check with my counsel at the table really quick? I'm sorry. So, Crystal, when you and Mr. Harris are interacting with hearing individuals, and you're watching him communicate, is he able to get everything?
Objection as to speculation based on lack of foundation, lack of personal knowledge. She is not him.
I think,
She may be right. I'm wondering what the word get means.
okay. So when you are with Mr. Harris, let's say prior to the crime, if you were out on a date, just out and about and you're interacting in the hearing world, are you watching Mr. Harris communicate and is, as you all are communicating? Are you watching Mr. Harris communicate with others?
Do you mean, when you say others, communicating with hearing people in the general public?
Yes.
No, it's not 100% perfect. He has to ask for them to repeat what they said to clarify, and then sometimes turns to writing or texting.
And when he is communicating, if he's lip reading, that's when he feels like, or when you feel like he might be missing a little bit.
Are you asking, when I observed him lip reading, was he missing some of it?
Yes.
Which is an objection to foundation. I believe the witness has said that she does not lip read. Isn't that correct? So how would she know whether his lip reading is correct?
I can explain.
Okay.
I apologize if the objection is improper. Maybe I'm looking for education for myself. Because I think there's a lack of foundation for this. And if I'm mistaken, my apologies. But
Let's proceed. Let's let them. I'm giving them some latitude here under the circumstances. I think that's appropriate. So let's go ahead.
Would you please explain?
My background is different in how I understand lip reading. Excuse me, the interpreter needs to ask for clarification. Okay, yes. So I went to a school where there was speech therapy, but he became more skilled using lip reading with his family. But when speaking with the average hearing person, no, I can't understand 100%.
Okay, I'm just getting a clarification. I'm being told that that Crystal has said that Rico does not understand 100%. So I just want to clarify that. Did you say that you don't understand, or did you say that Mr. Harris doesn't understand?
I don't understand 100%. And he understands when it's family only, because he reads lips with his family.
Okay, so when he is interacting in the general public, there are some challenges.
Yes, it's big challenges. When he struggled to lip read, then he has to start asking them to write or to text.
Ms. Starks, do you recognize the name Dr. Joseph Hill?
Yes. I know him because he interviewed me about language and culture.
And can you tell us a little bit about that interview?
He asked me about the variations and differences between how language is used in the deaf culture and in the general hearing culture. When I communicate with Rico, we use ASL. And when Rico communicates with his family, he doesn't use ASL, he uses lip reading.
And did you talk with Mr. Hill, I'm sorry, when you had the interview with Dr. Hill, did you talk about some of the challenges that Mr. Harris has with the general public?
Yes.
And do you have, it can be a very rough estimate, an idea of when you interviewed with Dr. Hill?
It was during COVID, so it was a few years ago.
And I'm gonna shift gears just a little bit. So I understand that you were his girlfriend, you were Mr. Harris's girlfriend at the time of his trial. Did you know that 3 women were going to testify against Mr. Harris at that time?
No, I didn't. I found out afterward.
And did you know any of those women?
I knew one, Christina Sandoval.
And how did you know her?
When I first met Rico, he introduced me to her and his daughter. That was back when we were in college.
Okay.
Okay, we're good.
So you knew her through Mr. Harris. Did you ever witness anything unusual?
I saw that they often argued. It was nothing serious, just everyday couple arguments.
When you were witnessing their arguments, did you ever, actually, I want to scratch that. Did you ever witness anything unusual, in particular with Miss Santaful? Just her individually?
That her behavior was impacted by her mental health.
Yes,
She struggled a
Objection
lot.
to lack of foundation, objection to improper opinion testimony.
I'm sorry, Your Honor, I wasn't trying to elicit anything about mental health. I can try to rephrase that.
Yeah, all right, ask your question again then, please.
Without going into Christina's mental state, did you see any behavior that struck you as very unusual? Anything very weird?
Not often odd behavior, it's mostly normal behavior.
Just a second, Your Honor. Honor, if I may, I just wanted to show her Petitioner's Exhibit 71, just to refresh her memory.
All right,
May I approach?
yes.
This is number 7.
71. So I don't want you to read that out loud. I just wanted you to take a look at that and take a look at paragraph 8. Well, I'm sorry, let me back up. Can you just tell me what you're holding? What is that?
It's from Rico and Christina, an affidavit from,
Clarification.
yes, clarification. It's my affidavit about Rico and Christina.
So these are, this is a statement that you have given previously. These are your words.
Yes, it's all my words.
Would you mind reading paragraph 8?
Your Honor, this is improper refreshing of a witness's recollection. If she remembers, she can testify, but it's improper for her to read a previous statement that she wrote. If she remembers, great, but if not, then.
Okay, I'm sorry.
Okay.
Can you tell me, does this, taking a look at this, does this help refresh your memory about what you've witnessed with Christina and Rico.
Yes.
And so, I'm actually gonna take that back. Thank you. So based on what you remember, do you remember anything unusual that you witnessed with Christina?
There was one behavior I found odd. Class was over, we were walking home, and I saw Christina in the bathroom. And she was trying to harm herself.
Can you describe that a little bit more? What did you see?
She was in the bathroom using socks with balls inside, and I noticed her hurting herself, causing bruises. And I asked her what was wrong, and she didn't know I was there. She thought I was still in class.
Should I clarify?
So I asked her if she hurt herself with that or if Rico did it, and she denied hurting herself.
So when you walked in, she didn't know that she thought you were still in class. And you saw her, you said, some socks with balls in them? Can you describe that a little bit more?
The interpreter's gonna clarify. So when I walked in, Christina was looking in a mirror. She had socks with balls inside, and she was hurting herself with the door.
Okay. So you saw, you saw her hurting herself?
Yes.
So you saw it before you asked her any questions?
So I saw her first, and then after I saw that, I asked her questions about it.
So you mentioned two things, so I'm going to ask about both. So you mentioned these socks with balls inside of them. Can you describe what the sock looked like?
It was a long white sock, and there was a ball down inside of it. I didn't see her hit herself with the sock and the ball. I saw her hit herself with the door and cause bruises. And she had in her hand the sock with the ball in it.
Okay. And so what you saw, can you describe how she was hurting herself with the door?
She was standing beside the door and she was slamming it onto her arm to cause bruises onto this, her arm from the door.
Okay, thank you. And I understand you did not know that she was going to be called as a witness against Mr. Harris until later.
Right, yes.
But I want to change and kind of talk about your communication with Mr. Harris's lawyers.
Okay, what do you mean questions about that?
Oh, okay. So
The first lawyer?
I'm going to clarify. Did you try to get in touch with the first lawyer on the board?
Yes, Tom. Yes, I did.
And were you able to talk with him?
No, I tried multiple times, but he never picked up the call.
How many would you guess is multiple times?
I would guess probably about 5 times. I did leave messages and hoped he would call me back, but he did not.
And what did you want to tell Tom for? Why were you calling?
So after I found out about the 3 women who'd be testifying, I offered to be a witness that, in a positive light based on my experiences with Rico at RIT, and I called multiple times, but he never returned my call.
And did you speak with Mr. Harris's second lawyer, Ashley Merchant?
Yes, I had successful communication with her by way of telephone as well as email.
And what did you want to tell Ms. Merchant?
I tried to explain about the 3 women and to make some clarifications about the evidence. Ashley said I can't repeat anything that was previously discussed in court.
So were you able to talk with Ms. Merchant about what you witnessed with Christina? It's
not exactly that situation. I wanted to tell her about Christina because it was in, evidence that was missing.
And what was Ms. Merchant's response to missing evidence?
She said, again, I can't repeat anything that was already said in the trial. I can only focus on things that are new information since the appeal. I can only talk about new information, specifically the communication it's used with witnesses. I can't focus on any evidence.
So is it fair to say that, well, I'll stop there. Okay, I'll stop there, sorry. I believe Mr. Oldham probably has some questions for you. Thank you.
Good morning, Ms. Starks.
Good morning.
You indicated to Ms. Matheson that you were never able to speak to Tom Ford. Did I understand you correctly?
Right.
I'm going to show you the document that Ms. Matheson showed you. Can I approach, Your Honor?
Sure.
I would like you to look at paragraphs 5 and 6 of that document. Please read them to yourself and let me know when you're done reading by looking up. If I may approach the witness again, Your Honor?
Yeah, you don't have to ask.
Yes, I probably had that back for me, Ms. Starks. Thank you so much. Ms. Starks, does that refresh your recollection about any conversations or whether you talked to Tom Ford?
Okay. I did not communicate with Tom Ford. He never picked up the call. The communication was that I left messages.
So in your affidavit, which you have executed previously, when you say told Tom Ford, you mean via voice, is voicemail correct? I don't want to use the wrong term.
Yes, it's called a video phone, and through my video phone, it allows me to leave him a message. So when I sign the message, it leaves him a message that he can hear from the interpreter who interprets the phone call.
So eventually you found out about the 3 women who would testify against Mr. Harris, is that correct?
And She's asking for clarification on the interpretation. The interpreter's clarifying. Yes, I found out after the trial.
So you never told Mr. Ford anything about those people?
But during the trial, I was not there. So I had no way of knowing. After trial, I found out, and I called and left a message for Tom.
You had communication with Ashley Merchant, though, is that correct?
Yes, successfully.
And you informed Ms. Merchant about your interaction with Ms. Santafel, is that correct?
Yes,
Ms. Starks, I believe, as you mentioned, when you were questioned by counsel, you are Mr. Harris's girlfriend, is that correct?
yes,
Since prior to 2013, yes?
yes,
And in 2010, you started a Facebook page, is that correct? I'm sorry, 2020.
Which page?
Innocent, deaf, wrongly convicted man.
Yes, and that was set up before that.
And also a website, freedeafricoharris.com, is that correct?
Yes,
And you went about finding an attorney for your boyfriend, is that right?
you mean, did I look for an attorney?
Yes.
Okay, I didn't look for an attorney. Ashley Merchant was provided by the court, was provided by the judge that from the trial.
I'm talking about after his appeal was decided for this habeas corpus proceeding.
Oh, okay, for this, yes, I made a video for Facebook. And Christina saw it through a vlog on Facebook and reached out to me and we moved from there.
So you're the reason he has a lawyer for this habeas proceeding, right?
Yes,
And you've been the driving force in the presence of the media attention at this hearing, is that right?
no,
Your Facebook page hasn't publicized this and garnered the attention based on your behavior on social media?
Well, you intimated that I was the guide. I'm not the lead on this. I'm a support.
You didn't start the Facebook page, Free Deaf Innocent Man?
That was just to put out information about Rico and to make people aware, because this is a unique situation with him being deaf.
So you had nothing to do with obtaining media attention from the outlets that are broadcasting here?
No,
No further questions subject to potential recross, Your Honor.
Thank you.
Thank you.
I have just a few more questions for you. I
Sure.
just wanted to clarify a few things. So on the statement that Mr. Oldham had you take a look at, and I had you look at earlier, you mentioned that you told Tom a few things. And I just wanted to clarify, when you made that statement and you're talking about that, when you say told, you mean you left messages?
yes, correct.
And those messages were never returned?
No, he didn't, correct.
So you all did not have a conversation?
Never, not once.
And then just for background information for the court, I'm gonna ask you just a little bit about the video film. Just so he can understand, so the court can understand how that works.
Yeah, sure. So with a video phone, it allows deaf people to make phone calls anywhere. They're able to connect to an interpreter anywhere through video. And then the interpreter who sees them on video interprets what the deaf person is signing. And then they also interpret back to the deaf person what the hearing person is saying. So it's really a 3-point communication. And it's just a way that hearing people can communicate directly with us through the video phone by going through an interpreter.
But on the hearing person side, they have a standard phone number. They're not engaged in a video.
Yes, hearing people just call on a regular phone.
No further questions.
Anything else, Mr. Stone?
Nothing further from responding, Your Honor.
Witness can be excused.
She can be excused. Thank you.
Thank you.
And Your Honor, for the court's information, counsel has been nice enough to allow us to take a witness out of turn because of our limited availability. And we have a remote meeting all set up. I just need to plug into the court's system and we can take the next witness right now.
All right.
That means that power over here, that was frustrating. Clark.
I can see you, I don't know if you can see me.
I can see you. Can you hear me?
Okay, yep, I can hear you.
Very good, very good. And I guess, can the court's reporter hear her, or,
No, just fine.
very good. And can you hear her?
Yes, I need to make sure I can.
Can the interpreter?
Yes.
Yes.
Okay, can you hear me okay?
Now I can, yes, I can hear okay. I may have to move a little bit.
Yes, like, just make sure you're not blocking.
Closer to the, yeah.
Oh, there we go.
Yeah, that'll help.
And
Okay.
there's the microphone on this thing.
If you're right.
There we go.
Hopefully so. So can the interpreters interpret properly? Can
Yeah,
everyone
it's like,
see?
just make sure you're not blocking Mr. Harris.
No, I want to make sure everyone can see.
Okay,
Is
we're good.
everyone's okay? Your Honor, may I swear the witness?
Sure.
Ms. Clark, could you please, do you solemnly swear or affirm the testimony you're about to give this court, the matter not pending before, be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you please state your name?
Laura Clark, no E.
And Ms. Clark, how are you employed?
I am a sign language interpreter.
And as a sign language interpreter, how long have you been interpreting?
Over 20 years, closer to 25 years now.
And if you could please, what is your educational background?
Okay, I have an associate's degree in sign language interpreting and a bachelor's degree in deaf education and a master's degree in college teaching and administration.
And in terms of your career as a sign language interpreter, do you have any manner of professional certifications?
Yes.
What are those?
So I got my National Association of the Deaf certification in 1998, I believe. And then in 1999, I got my certification through the Registry of Interpreters for the Deaf. It was called the Certificate of Interpretation and Certificate of Translation, and at that time. And in 2003, I got my certificate, my specialty certificate in legal interpreting. And then since that time, they've come out with another certification called the National Interpreter Certification. I got that as well at the master level.
And when did you get that master's certification?
I want to say around 2012,
Now,
but
sorry.
I don't remember exactly, sorry.
So prior to your involvement in Mr. Harris's case, is that right?
I believe so, yes.
So he's a special certificate legal in 2003, is that right?
Yes.
What all is involved in obtaining that level of certification from RID?
Okay, you have to have your generalist certification first, and then, God, it's been so long. I believe it's 50 hours of specialties, workshops, and training in the legal field. And then there is a written test that they test us on, and then a performance test.
And that is the initial certification, is that right?
No, that's for the specialist.
For the special, that is to obtain the specialist certification?
Right.
And
And you also have to have a bachelor's degree as well.
once you obtain it, is there any manner of continuing education that you have to perform to maintain the certificate?
Yes, to maintain our generalist certification, we have to have 80 hours of CEUs or continuing educational units every 4 years. And as a specialist as with a specialty certification, we have to have 20 of those hours in the legal realm or with legal field.
And are you current on all your certifications in that respect?
Yes.
And were you current on your certifications at the time you served as an interpreter during the proceedings in Mr. Harris's case?
Yes.
How did you come to be involved as an interpreter in Mr. Harris's case, if you can recall?
I'm a contractor. I work for agencies, and I was just asked to work a trial by an agency that's a contract with the court.
And in working the trial, what role did you serve at the trial in Mr. Harris's case?
I was one of two of the proceedings interpreters working for the court.
And who was the other proceedings interpreter, if you can recall?
And Zimmerman.
And do you know whether, or do you recall whether you were a proceedings interpreter at just the trial or any pre-trial proceedings?
Pretty much for the trial. I think there was a brief meeting with the attorney beforehand, and we did ask the judge if we were able to interpret for that, and we did. We communicated prior to the hearing for the trial.
So with the registry for interpreters for the deaf, why is it interpreting for the deaf or interpreters for the deaf?
Interpreters.
So with RID, are there protocols for how the hearing actually works? It kind of prefatory matters that you address prior to actually the interpreting starting?
Typically, the attorney will hire their own interpreter to interpret between themselves and the client. I'm not aware of all of the prior meetings that they had. So as far as I'm aware, I don't remember there being a personal interpreter for the attorney, because typically we will have an interpreter for the attorney. And usually if it's a public defender, the court will provide that. But in this situation, I believe it was a private attorney. So he did not hire one.
So was there ever an arrangement about serving as a conduit for the lawyer and the client at all during breaks or anything like that?
During breaks, we had asked the judge, actually the attorney had asked the judge if we could communicate briefly on breaks, make sure he was understanding, or if he had any questions. And yes, we did do that. There was never a time where he said he wasn't understanding something, as far as I can remember. Now, this was 10 years ago. And because for interpreters, when somebody says they're not understanding, it's a very big deal for us. So, yeah.
Is there a mechanism for that? Is there a mechanism during trial through which you and Ms. Zimmerman would be on the lookout for lack of understanding?
Yes, and typically, yes, we do try to manage watching facial expressions, or they'll tell us if they're not understanding, but we can't always gauge whether somebody's completely understanding everything that's being said.
Right. Were at any point in trial, when you're interpreting in general, is it common for the person you're interpreting for asking for clarification or indicating lack of understanding if they don't?
Now, for a trial, we typically will indicate for the client to tell their attorney if they're not understanding something. And usually they'll have their own interpreter at the table with them to tell their attorney that. In this case, there was not one. They were using pen and paper to communicate back and forth. However, at any time, a deaf person can say if they're not understanding directly to the interpreter, and then we would have to inform the court.
So that's happened with you before, yes?
Yes.
It probably happens not infrequently, someone asking for clarification or someone indicating a lack of understanding or confusion. That happens.
Yes.
And we
also have, if it's somebody is not understanding at all, we will typically pause, ask to bring in a specialist, which is a deaf interpreter, certified deaf interpreter, to work with us. If there's a language level that needs to be a specialist brought in for someone, and that does happen.
And is it your practice to have an initial interaction with the person for whom you're interpreting to vet their communication style, or to ensure kind of an understanding? Is there kind of a threshold conversation? Does that make any sense in mind?
Yes, typically we'll introduce ourselves, ask them where they went to school, try to get a gauge of their language style, yes, before the case starts. And we don't talk about the case at all. We just try to have, brief conversation to be sure we're understanding each other.
Do you recall whether that happened in this case?
Yes.
And
yeah.
please, I didn't mean to interrupt you.
I was going to say, I felt we were understanding, communication was clear, and there was never an indication of not understanding us.
And what about during the course of the entirety of trial. I know it was forever ago, but to the best you can remember, was there ever a point when there was an expressed lack of understanding or confusion or anything like that to make you think there was a lack of understanding?
No.
No further questions subject to potential redirect, Your Honor.
Thank you. Ms. Matheson, any questions?
I do, yes. Sorry. Good morning, Ms. Clark.
Good morning.
Thank you for squeezing us in. I know you can tell.
Yes.
So I'm just going to kind of walk through some of the things that you just discussed with Mr. Oldham and just sort of ask for some clarification on a couple of things. The first thing, how you described it, it was just the two proceedings interpreters at Mr. Harris's trial. Is that correct?
Yes,
There was no table interpreter, correct?
correct.
And what is the general function of a table interpreter?
They're able to have privileged communication between themselves and their attorney during the trial. That is not something the proceedings interpreters are able to walk over and do during the trial. And also, they're typically there for any sort of break or any side conversation between themselves and their attorney.
And so that was something you just said that you were not able to really assist Mr. Harris with, correct?
Well, we did dispose of the request from the court, and we were able to, on breaks, briefly just clarify or ask if he had any questions.
But you weren't able to assist if there was if the attorney had a concern or if he had something that he wanted to relate to his attorney in that moment.
Correct.
And how does a defendant in a criminal trial typically object to an interpretation error in real time, like a contemporaneous objection? Have you seen that happen? Can you describe that for us?
Typically, they'll tell their table interpreter or interpreter for counsel to tell the attorney if they have something they would like to object to. And then the attorney decides whether they want to make the objection or not.
And so that would be something that they would not be able to tell the proceedings interpreter, because that would be something that would be between counsel, correct?
Correct. And in this case, I know they were writing notes back and forth if he had anything he needed to tell his attorney.
And can you describe the general best practices?
General best practices is to always have an interpreter for counsel for trial, and to proceedings interpreter working, interpreting for everybody else in the courtroom. And depending upon language needs, having certified deaf interpreters as well at the table and working proceedings.
So just to clarify, so what you're talking about, the general practices are two proceeding interpreters. And then when you say the first interpreter that you referenced, that's the separate interpreter at counsel table with the client. And then depending on the client's needs, there might be a need for a second, what's called a certified deaf interpreter to assist the hearing interpreter and counsel. Is that correct?
Correct. Yeah.
Sorry, I'm just checking my notes really quick. You had mentioned that you met with Mr. Harris and with his lawyer shortly before the trial started. Kind of just went over, you didn't discuss the case, kind of went over what you might expect and his level of understanding, correct?
Yeah.
And
No, that's as far as I can recall.
I I think you had mentioned you had to get permission from the court to do that. Is that correct?
Right, typically if there's no table interpreter or interpreter for counsel, we will ask the judge if the court's interpreters can interpret briefly for counsel, if there's anything that needs to be clarified.
And why would you need the court's permission to have that clarification conversation?
Since at that point we are interpreting privileged communication and we are the court's interpreters.
And you would not then engage in any kind of privileged communication after that?
After what?
After that initial conversation where you're kind of discussing where the interpreters are going to be and his level of understanding.
Well, during the trial, we were, during breaks, asking if there was anything that he needed clarified or had any questions.
And did he, but there was no opportunity as the trial was going for him to do that contemporaneous objection?
Correct. Unless you wanted to write it down and have his attorney address it.
I'm going to show you a document. I've marked it as Petitioner's Exhibit 76. Your Honor, I'm going to show opposing counsel. This is and I can approach the bench, Your Honor. So just for the court, this is a document that's actually been appended to one of petitioner's previous motions. And I'm just going to ask, I'm going to kind of hold it up to the camera. I don't know if you'll be able to see it. I'm not going to ask you to read it, but hopefully it looks familiar. Do you recognize this? And what is that? What is this document? I'll hold it again. Just.
Is that the, usually, is that the words form that they use to swear the interpreters in?
Yes, yes.
Okay.
And is there, I don't know if everybody, I don't know if it's a ubiquitous term, but is there a standard thing that, term that you use to reference this? Is there something that you guys call it?
Not that I'm aware of.
Okay. Is it safe to say this is sort of like a shorthand version of just these are the best practices?
It has been a long time since I've read that form, so all I'm familiar with is the oath that they use. I'm not sure what the rest of the form says.
Okay, that's okay. Nothing further, Your Honor.
All right. Anything further?
Thank you, Your Honor. Clerk, you indicated that best practices can potentially lead to the need for a certified deaf interpreter at counsel table. Is that right?
Correct.
What kinds of things clue you into the need for a certified deaf interpreter?
Typically, a deaf person that has what we call language deprivation, who has been, their education may be where they have not become fluent in American Sign Language, or they read at a very low language level. It could also be a person from another country who doesn't use American Sign Language, and we need somebody to work with them. Or their language is just, we call idiosyncratic, some sort of form of non-American Sign Language. But it's always best practice to have an extra set of eyes as well for legal situations.
Okay, but the baseline criteria that you just described for thinking that it would be a best practice to have a certified deaf interpreter, did any of those circumstances exist in this case so near as you and Ms. Zimmerman understood?
No.
And you've been interpreting for, I think you said for, I don't want to short you, 30 years, is that right? Or
About 25.
25 years? And have you seen it in a criminal trial with a deaf defendant where there's not an interpreter at counsel table? Other than
I have. Yes, but it is becoming more common practice now, to typically have a certified deaf interpreter. I would say 10 years ago, it was, something that we did, but it wasn't as much of, we feel it's almost a requirement now. 10 years ago, it wasn't as strong of a requirement that we were following then.
But that's just with the certified deaf interpreter, you said.
Right.
What about just an interpreter period at council table? Have you had other cases?
Yes.
At the time you interpreted Mr. Harris's case in 2015, and then the proceedings leading up to it, had you seen other instances of there not being an interpreter at council table?
I had, yes. Probably not so much 10 years ago that we weren't using deaf interpreters and certified deaf interpreters. Probably more like 20, 25 years ago, you didn't see it as much.
But in terms of no interpreter at all at council table, was it more common 10 years ago to not, and in the years before, to not have an interpreter at council table?
No,
So,
it was not typical. It was not a typical practice, no.
but it did happen and you had seen it.
Yes,
And I think you testified in those circumstances, the attorney and the client, you witnessed them communicating in writing between one another. Is that correct?
yes,
And that's what you saw in this instance, I believe you testified?
yes,
You saw Mr. Ford and Mr. Harris communicating in writing?
yes.
And just so I make sure I understand you correctly, the communication you facilitated between attorney and client during breaks, that was just, that there were procedural matters? Was there anything about the case they would talk? I know it's been forever, but to the best you can remember.
Right. Like I said, it was to ask if you needed anything clarified or if there was any questions.
And again, just going off of your memory, to the best you can recall, which is all we can ask of anybody, do you remember there being anything that Mr. Harris needed clarification on?
There may have been some questions, but it was never lengthy. It was very brief. It was 1 or 2 minutes and that would be it. And that's as far as I can remember, right?
No further questions subject to potential redirect, Your Honor.
I have a few questions, John. So, Ms. Clark, I have just a couple of questions, a couple more clarification questions. You were talking a little bit about whether it was common practice. Well, it sounded like it's common practice to have the table interpreter, and it is not, I think you said it's not the typical practice to have just the proceeding interpreters. Did I understand that correctly?
Yes.
And when you were saying that you had seen trials prior to Mr. Harris's trial, where there was no table interpreter, have you seen any other murder trials in which there was no table interpreter?
Yeah.
And just for clarification, when you and I were talking about the contemporaneous objections and the need for clarifying interpretive error, it's not for the defendant to object, correct? It would be the attorney who stands up and objects.
Correct.
And the attorney.
As far as I'm aware.
Right. And the attorney would be informed of the need to object through whatever's happening with the table interpreter and the defendant, correct?
Yes.
And just kind of one last thing. the proceedings interpreters are officers of the court, correct?
Yes,
And so as officers of the court, it is very important to have neutrality. Is that correct?
correct.
If I could just confer with my
Sure.
interpreters. So just one last question. So if you do ultimately have to interpret privileged communication, what does that do to your neutrality?
I guess typically it can sway that neutrality. I mean, it can. That's why we like to have the table interpreter. Yes,
Thank you. Nothing further.
you're welcome.
Ms. Clark, you would interpret only as between attorney and client, even procedural matters, only with agreement of the parties of the court. Is that correct?
Correct. Yes.
And did that happen in this case?
Yes.
And obviously, as you've referenced, with no table interpreter, the ability of a client to convey to the attorney to object is on paper. Is that correct?
Correct.
And I know this is totally absurd to ask you to think that whether you saw this, but on the off chance that you remember, do you ever remember a time during trial, trial counsel objecting because of something petitioner wrote to him? Did you ever observe that?
I don't remember.
Yeah.
Yeah.
Just check. Thank you.
Mhm.
Sorry, we're just trying to be absolutely clear.
Yeah.
So when an objection is made, it's the attorney needs to recognize that there has been an interpretation error. The attorney needs to recognize that the words are not being interpreted as precisely as they could be. Is that correct?
Correct.
Thank you.
Anything else?
Nothing from responding. Your Honor, we ask that Ms. Clark be excused.
Thank you. You may be excused, Ms. Clark. Thank you.
Thank you.
Thank you, Ms. Clark.
All right, we're going to take just a brief recess and we'll come back. Let me ask, any further, I'd say you had maybe a couple more witnesses for today.
Just one more witness, Your Honor.
Okay.
And then Mr. Oldham and I, sorry to put him on the spot when he was trying to deconstruct. But we talked a little bit before we started today, just to confirm that we're on the same page of using the briefs as our closings.
Okay.
So the last witness, I think should be,
Should wrap everything up. All right, let's just.
and then the documents, yeah. Yeah, that's
It's gonna take a minute.
Let's take about 10 minutes, we'll come back and pick up from there. I have this exhibit, the petition exhibit number 76 up here. It was handed to me, but I think maybe I'll.
She
ended up not
really using it, so.
All right.
I can feel it.
Everybody for me, yeah. Much. Sounds familiar.
ahead.
Can you, leave the door open? You guys, it's better for you.
Yeah, it's easier.
I think it's like, see.
I mean, it doesn't matter.
Thank you, thank you.
It's okay if it's close.
Can you raise your right hand? I, Felicia Hubbard, do solemnly
I,
swear
Felicia Hubbard, do solemnly swear
to tell the truth, the whole truth,
to tell the truth, the whole truth,
so help me God. Sorry, I lost my voice.
so help me God.
Good morning, Ms. Hubbard.
Good morning.
I'd like to start just with a little bit of background. So how do you know Ricardo Harris?
I went to school with him.
And when did you attend school together?
A long time ago when we were little.
How old were you and how old was he when you guys met?
I believe we were 4 years apart. This was in elementary school.
And who's older between the two of you?
I'm older.
So you all met in elementary school. Did you go to school in elementary school, junior high, high school together, or was there a point where you went to different places?
We were together in elementary school, and then we split after that. Not in middle school.
And what kind of school did you go to?
A mainstream school.
You went to a mainstream school?
Yes.
And then what kind of school did Mr. Harris go to?
Mainstream.
They were just different schools.
It was the same mainstream school.
Sorry, when you went into junior high and high school,
Okay, so middle school we were together, but in high school I went to the deaf school and he stayed in the mainstream school.
so you went to the deaf school, he stayed in the mainstream. And what language do you use to communicate?
ASL.
And growing up, how did you see Mr. Harris communicate?
I want to clarify. You mean growing up, he signed English or now more ASL?
Okay, so when you were littler, he would sign English. And now he uses more ASL.
Yes.
Do you recognize the name Dr. Joseph Hill?
Yes.
Who is he?
He studies communication, specifically linguistics.
And did you have an interview with Dr. Hill?
Yes, through video.
Do you know about when that happened?
I want to say 2 years ago, if I'm remembering correctly.
And can you describe that interview?
He asked me questions about Rico.
Do you recall what you said?
He asked me how well I knew him. The interpreter needs to ask for clarification, Your Honor. May the interpreter ask for
Sure.
clarification?
Yes.
He asked me questions in regards to how well I knew him and what his communication skills were.
How well you knew Ricardo Harris and what Ricardo Harris's communication skills were?
Yes, his skills. Yeah. Basically, yeah. Yeah, there were more questions, quite a few.
Can you remember a little bit more of what you might have told Dr. Hill?
I'm sorry, it's been 2 years, but I'm trying to remember. We talked about language access and accessibility. We talked about rights as a deaf interpreter myself and having a deaf interpreter within the system. I think that's all.
And I just want to clarify, when you say system, do you mean the legal system?
Yes. Yes. In order to avoid mistakes, it's better to have, you should have a deaf interpreter there. Anytime there are any issues that could go awry, you should have a deaf interpreter there. And you think about that in terms of language deprivation, whether it is ASL or Chinese or Spanish or any language.
Just
My English is not my first language.
Objection to improper opinion testimony unless petitioner wants to tender her as an expert in linguistics. I believe this is improper testimony.
I'm sorry, Your Honor. I was just about to ask her. She had mentioned, Felicia, you had mentioned that you are a deaf interpreter. Is that correct?
Yes. Yes, ma'am.
And so I was actually going to ask, what is a deaf interpreter?
Okay.
Okay, I'm still in training as a deaf interpreter. I grew up helping others communicate and understand I helped with when they were trying to understand with the hearing interpreter. And I'm sorry, I'm having a challenge with this process. So if there was a hearing interpreter or they signed really fast, I would work with the deaf person to kind of summarize and communicate with them because we had that shared experience and knowledge. So if things were, too fast or something, I'm still in training though. And this consecutive process of interpreting is not familiar to me. So as an individual, I didn't have we had the same mainstream education, Rico and I, but I went to a deaf school as well.
Thank you. So you mentioned that you are still in training. So you're a deaf interpreter, but you are not a certified deaf interpreter, is that right?
Right. Yes, you got it there.
Can you describe the difference between those two things?
So I've made appointments to take the written test. I have to do that, but I'm not certified yet.
Just for clarification, interpretation, did you mention that there's also a performance test that you need to take?
Yeah, I have to take that test in order to be recognized as certified by RID. So I don't interpret in court. I can't. I'm not certified yet.
The interpreters need to clarify to be permission.
Yes.
The court requires that I have completed the performance test as a certified interpreter. I haven't done that yet.
So when you were testifying earlier as a deaf interpreter, what are some circumstances where you can be a deaf interpreter?
Like at someone's IEP, individual education plan, those meetings in schools. Like doctor's appointments. And maybe not all doctor's appointments, but dental appointments. It's simple appointments when you're not certified. Simple things that don't require certification for a deaf interpreter.
And you had mentioned just a minute ago that you went to a deaf school in high school and Mr. Harris did not. Can you explain why you're mentioning that, what the significance of that is?
You mean why it's important to me or to him?
I guess what I'm asking is, you had mentioned it, and so I'm just sort of asking, what differences did you see between the two of you as results?
At the deaf school, we were exposed to ASL, and he stayed in the mainstream where he didn't have that option. I had more access to language. That's the difference of going to the deaf school, language.
And is this the kind of thing that you spoke with Dr. Hill about?
Yes.
And were you available in the summer of 2015, at the time of Mr. Harris's trial, to testify?
2015. They didn't call me.
Did you ever speak with Tom Ford?
No, and he didn't call me.
If he had called you, would you be willing to testify?
Yes, but he didn't call me.
No further questions.
Nothing from respondent of this witness, Your Honor.
All right, thank you. All right, you may sit now. All right, anything further from the state or from the defense or either? I understand that you wish, both of you wish to file a brief on this, and am I understanding that in lieu of a closing argument?
Yes, Your Honor. Well,
So to answer, I guess, the court's questions kind of in turn, opposing counsel was nice enough to allow us to take Ms. Clark out of turn. So we have no more witnesses, but we do both have no shortage in the way of documentary evidence. But about briefing schedules in lieu of closing argument, we would simply ask for a reasonable amount of time after the transcript of the evidence in this case had been prepared to provide proposed orders or post-hearing briefs, whichever the court prefers. And if the court is agreeable, considering the size of the record and the amount of grounds that have been raised, we would ask as the responding party the ability to submit our brief within a time after petitioner has. And then of course, petitioner would then have time after we submit ours to submit a kind of supplemental argument, if the court is agreeable.
petitioner's amenable to that.
We're looking at a couple of months with it, mainly because of the volume of the material that you're going to be submitting, I think. So we'll just kind of operate on that. That would be around the 1st of July sometime, I suppose.
Understand, Your Honor. Usually we ask for, in cases like this, for the petitioner to have no less than 60 days, unless you would like more upon receipt of the transcript. And then we would have at least 30 days after our receipt of their argument. And then they would then have, then she would have 15 days after her receipt of ours. Is the court okay with that
That's
schedule?
fine. I'm very flexible. I'll let y'all are working together with this, and I'll just, I'll accommodate any reasonable request. And I would seem to think that everything y'all would ask would be reasonable. So we will just let the transcript get prepared and send that to you, and that'll be day one, and we'll look 60 days after that for the first brief, and then beyond that, I'll go along whatever you want to do.
Thank you so much for the accommodation, Your Honor. Thank you for being so flexible.
Okay. All right. Well, I want to thank everybody for their participation. This has been, I've been on the bench since 1983, one way or the other, and I've never participated in any proceeding quite like this one. Y'all have done a real good job in making the presentation of this, and I appreciate the interest that not only that this matter is brought to the I would say the deaf community, because we're having people watch in and watching this, and so I think it helps us move a little further down the road toward a better understanding. So I'll be as quick as possible in making our bringing this to a conclusion as soon as it's practical. But thank you all for your patience with me, and I appreciate having the opportunity to be with you. Do you want to? I can.
We do unfortunately have a lot of documentary evidence to tender and admit before the court.
That'll be fine. I can do that.
I know it's onerous, but unfortunately it's a hurdle we've got to jump.
Unless there's some confusion, some objection by one side or the other to the, we can just let everybody just put it on the record as to what these items are without going through a whole lot.
I think we can you want to identify what you're tendering, and then I'll say if we have an objection to it. Does that work for the court? And then I have some things that are almost supplemental of what she's tendering.
That's fine. We don't have a jury in the box on this. I'm capable of kind of sorting through what's the wheat and the chaff. So
I understand, Your Honor.
I know mine is quite voluminous, so I will try to make mine brief as I walk through it. I tried to, I tried to make it groupings, so I can maybe make that a little bit easier as I kind of walk through. So, Your Honor, the first, let's see how far we go. First 27 exhibits for petitioner, I believe, are all exhibits from the record on appeal.
And we have no objections to any of those.
okay.
And I believe, when Mr. Oldham's right, those are the ones that he's planning to supplement. And then the remaining exhibits are records that, as post-conviction counsel, I was able to collect. So 28 through 31 are records that I received directly from the Marietta Police Department. Given that time frame, I put the dates on here so you can kind of see the 2020, 2020 exhibits. It was during kind of the height of COVID. And so I was able to go in person later to get some of these electronic files and that kind of thing. So that's the 2021 supplement for exhibits 29, 30, and 31. The reason that there's two, or two sets, if you look at
Your Honor, unfortunately, with what counsel has referenced as post-conviction discovery, we do have to object for lack of foundation. In effect, counsel is serving as the foundational witness for the admission of evidence. There's no independent basis to admit these things. We would object on those bases.
Your Honor, these, I did request certified records. I was not actually given the certificate, but I have requested multiple times that they be certified so this court would understand. This is kind of a matter of routine for post-conviction.
These are all public records.
They're all public records, yes, Your Honor.
I'll take them. What value they would be, but I'll that you put them in.
Similar with the GBI, and actually Exhibit 34 contains 32 and 33. They are,
And the GBI records are actually duplicative of evidence admitted at trial, which is part of our tender. So we have no objection to the GBI
All right.
records.
and then we have, Ms. Harris came and testified, I believe the bulk of 35 through 53 were either admitted through Ms. Harris or through Mr. Ford already. I think what we had reserved on my notes, I have 43, 44, and 52 for me. Is that correct?
That's one of which is the transcript cost, is that, or the resume.
Oh, I'm sorry.
And the sister's notes, yes.
So was it 50, not 52?
I-
It's the resume.
The resume was the old 51, and then.
Okay.
52.
Okay, sorry.
No, I'm not.
So for his sister's notes, and also her research, Mr. Ford mentioned multiple times that he did not have a defense, and he was really looking to Mr. Harris and to Mr. Harris's family for defense. And so these were what I was, and I remember telling this court I had sort of a chicken and egg problem. But I was,
Your Honor, I don't recall him ever actually identifying them during his testimony.
I don't remember seeing a document with that on it. I mean, she talked about some of her work that she'd done on her own research. I'm gonna let you put it in. I don't know that it's gonna be very dispositive of anything. I wanna be broad as I can to let you to,
thank you, Your Honor.
but I don't. Let's let it in. I see that we held off on 43, 44, 45, but I'll allow those. That's what you want to do.
Thank you, Your Honor.
And I think we went through,
So if we're moving on, Mr. Ford took a look at these documents regarding co-defendant Ansel Neal. We kind of walked through.
Yes, Your Honor, all exhibits 54 through 68, the court admitted yesterday for the limited purpose of head-on counsel.
And then we have the affidavits, which I understand that there are some objections to.
And yes, no shortage in the way of objections to.
But I think we had talked about that as a preliminary matter, potentially addressing those objections. Written form, I don't know if we want to do that when we do the briefing or if we want to do that earlier, but petitioner is still fine addressing that in a written manner if that plan works.
And I'm, like we represented at the onset of the hearing when the court asked, perfectly fine to address the admissibility of the affidavits in a written argument after this hearing, if the court is on board with that.
okay, that's good. I know that I think some of that had been previously sent to me, or at least it's been filed, and I got a notice of it. That especially with I think Dr. Hill's affidavit and his report of his, it's called Report on the Education, Language, and Communication Context of Ricardo Harris. Yeah, I'm a little concerned that he was not here, he did not testify, was not subject to cross-examination. It kind of bothers me to accept it, but I think I'd allow it as an exhibit, but the value of it, I think, is probably subject to scrutiny by the court. But I don't, maybe I'm making a mess here. What do you want to do? You just don't want it in the record at all?
Your Honor, we acknowledge that there are components of Dr. Hill's affidavit and accompanying report that are admissible. But we also maintain, as we touched on in our initial motion to exclude, that there is a significant percentage of his report and affidavit that we believe do not sustain or do not withstand evidentiary objection. And that was the point of the initial motion to exclude, just to kind of clue the court into that we're not going to be blanket agreeing to the admissibility of this document because it's our opinion that it doesn't satisfy or withstand evidentiary objection. That would be my response to the court, that it contains no small amount of what is, in our characterization, in our opinion, inadmissible evidence.
Well,
I know
you can state, I mean, you can make that argument, make that statement, and I can take it. I'll accept that as the argument. And if I'll say I'll give it the credit it's due, and if it's not something that states have an opportunity to cross-examine the witness on, I'm unlikely to give it a lot of thought. But for the purposes of making a record, maybe it ought to be in the record.
I understand, Your Honor, and if we simply might have the ability to further explain our motion to exclude, and just a very brief post-hearing brief highlighting every component.
And be specific as to which part.
Yes,
I
absolutely.
mean, you said some of it's okay, some of you have concerns about. Just make sure you make it clear what you're concerned about and the reasons for.
Yes, and we would submit, Your Honor, that every component of the affidavit and accompanying report that we don't specifically delineate in our supplemental brief on this as objectionable, then we would implicitly acknowledge that it's likely admissible. So everything we don't say is
Okay.
objective.
All right, that's good. Okay, so we'll
And we would ask for that ability to address all four of the affidavit. Actually, 3 of the 4. Exhibit 71, the affidavit testimony of Ms. Starks, we would, I don't know, are you planning on tendering that?
I mean, I guess I said never did that, sorry. I was, but we did have Ms. Stark's live testimony, and, I presume that the court probably wanted.
Is that just that one sheet?
It's 2 pages, but I think the second page is very short. I think it's basically her signature.
But we would ask,
Well,
sorry.
I think since she was here and did testify, it's probably, let's turn that one down. I'm 71 since she was here.
But if the court is agreeable, we would like to submit a post-hearing brief on the admissibility of Exhibits 69, 70, and 72, which are the affidavits of Joseph Hill, Manisha McElwain.
Yes.
McGowan.
Thank you. And Christopher Tester. Thank you, Your Honor.
And then that just leaves
three more exhibits. So we have the for disciplinary action, which is publicly available. We have Mr. Harris's prison records, which is fairly short. And then I have Harris writing samples, which were relied upon definitely by Dr. Hill. I can't remember if Dr. Tester also relied upon them, but just putting them in there for the sake of completion.
Okay. Any objections to any of those?
Your Honor, the prison records is the 2023, I believe, records of petitioner. I don't really, I understand the court is perfectly capable from separating that which is relevant from irrelevant, wheat from the chaff, but I don't see how it's relevant to the question of.
I don't think anything's been said about his conduct in prison. I probably don't need to even know about all that. I mean, it may be good, may be bad, it's just not really relevant, but what's relevant is happened many years prior. So, I think that.
Your Honor, if I may, like I said, they're very brief. He actually has an exemplary record, which is why they're so brief. And it was actually quite remarkable that he does not have the disciplinary reports or anything like that. So that's partly why they were put in there. I recognize that they don't go toward his behavior in 2013 or 2015 at the time of trial. But again, just more for the sake of completeness, so this court has a full picture of who Mr. Harris is.
Let's just leave him in there. Let's put him in.
I understand. We would maintain our objection for the reasons that the court kind of explained. The completeness matters in the proceedings resulting in conviction. What's happened, that which has happened after, and since the petitioner has been incarcerated on the convictions. I understand, Your Honor.
I'll give it, if you do notice.
And about writing samples, again, I don't understand the relevance of his writing samples.
I don't know either.
I know counsel is, it's something that Dr. Hill, I believe, reviewed. But I don't understand the relevance.
It was something that he referenced in his, Dr. Hill, referenced in his report. And he talked specifically about Mr. Harris's writing style.
Contained in the report, the same stuff?
To be quite frank, I don't know if he quoted from these writing samples. I just know that he referenced them and he put them into his linguistic, he maintains a database and put them in there. But it was, Mr. Ford talked, and I think even Ms. Clark today talked a little bit about how Mr. Harris would write with his attorney, and that's what they were sort of dependent on for identifying any kind of interpretation errors at the time of trial. So his writing is actually relevant.
Okay, I'll receive that. Instead of that, that'll be fine.
And I think that's it for petitioner.
And Your Honor, might I make my tender at this point?
Yes.
Thank you, Your Honor. Showing counsel what's been previously marked as respondents exhibit 1 is the clerk's record and petitioner's direct appeal. Respondents exhibit 3. I apologize for the odd numbering. They were sequential had I forward to tender duplicative things. Respondents exhibit 3 is the pretrial motions hearing transcript.
Okay.
Respondents exhibits 4F.
Let me see if we, yeah.
I have no objection to 1 and 3.
Okay. Sorry. Let me know if you've got an objection, let me go through it. It's something you.
Yeah,
know.
I'm going as fast as I can.
Respondents exhibits 4F, 4G, and 4H are the 3 volumes of exhibits and petitioner's trial. Sorry.
That's all right. That's all right. And I have no objection to the exhibits.
And respondents. On the list. Your exhibit 26, is it the DA's brief or is it our brief? Because they're two, they're two.
Oh, okay.
Apologize, Your Honor. Uh,
26?
Yes.
It's yours, it's yours.
Respondents Exhibit 8 is the brief of the district attorney in petitioner's direct appeal.
No objection, Your Honor.
And Respondents Exhibit 10 is the affidavit of Ann Zimmerman, which we noticed petitioner of our intent to admit. All right, within, 10 days in advance of the hearing as required by the statute.
And I've read through it, Your Honor. Petitioner has no objections to Ms. Zimmerman's affidavit.
And that completes our tender.
All right. That it?
That's it. That's it.
Okay.
Respondent rests.
All right. Thank you all very much.
You have no exhibit 2.
So Exhibit 2 would have been the motion to determine competency of
Fine,
counsel.
I'm just double checking to make sure I'm not missing something.
Yes, thank you. I also have no 4A through E.
Is that what's in all these boxes that are up here?
Those are petitioner's
Those
exhibits.
are all.
And there's actually a duplicate copy. So there's one that, some binders for the judge to go through if you want them, and then one for you. Yeah.
All right. And if I may approach the court's reporter with these?
You certainly may.
Thank you. And that concludes our tender.
Just, 7. That's all of yours.
And the gaps would have been the gaps in numbers.
All right, thank you.
Okay. All right. Thank you, folks. Thank you very much.
Thank you, Your Honor.
All rise.
Now it's my kids.
Usually the exhibits and everything.
So I've got it. I have a typist. Last night I just
So what, Susie wants.
She did. Little John. By the way, I didn't like
Yeah, I need to.
No, I will. I'll email one back.
All the little fucking guys.
Yes.
You can't help ourselves.
Well, thank you for coming. I appreciate it very much. I know he appreciates it.
I know, I'm not going
This seamless. It's real concern. Just you all in it.
Yeah, that support
Yeah.
that I was in the table.
So,
And the staff here, I mean, I've been here for 4 years, and I'm telling you, the staff here are some of the kindest. But sometimes they're each other, and they don't really do it. Well, sometimes they're like, but all of the staff here are like, what can we do? I love that. Could you just do a better job when you just keep. Yes, I think our building makes us stay humble.
Among other things.
They belong to you,
I
Mrs.
don't
Green.
really get anything going on. We're not doing anything else but fabric in here. I'm gonna leave all this stuff. For now, we'll let them put some of those boxes. And, yeah, they need a car to load them in, put them in the office.
I think you're right. That, you're right, 100%. Thank you, you're right.
First page.
That's it.
Since he's a senior judge, he has, and he's like, yeah.
Well, we just kind of do one. This
That's right.
Yes, this is, yeah.
2 days are.
I'll get the car.
Yeah.
That's so much.
Thank you.
No, actually, it was. She's not finished. I needed to learn. No.
That's it. That's what that- You get to pick and choose which one fits, so, but it's a funny thing.
Well.
All I'm saying is a pleasure working with you. I really enjoyed it. Thank you so much.
I know.
Oh, thank you so much.
Yeah, I mean, I'll definitely.
Anna, do you need anything? Good to know. So,
Yeah.
Now it's not custom.
I'm terrified.
Now it's new style.
Okay, I've got a card. We need you to mention me what's going on.
Right.
Usually.
That's why I'm
But
asking
I
to write,
work-
like, I'm telling you,
I will lose it or I get
I'm a
rid of
nerd.
it. Are you sure you didn't get the whole thing?
You know what, I actually don't think so, because I just got my 2 boxes. Thank you, the court protocol.
Pleasure in communicating, I'm sure.
Pleasure meeting you in person.
It's really nice to meet you.
I know, I'm in my heart.
Yeah, you too.
Where is that for you?
Maryland.
Okay, that's back.
Yeah.
Thank you all.
He's driving to India. Oh, really? Right now? Like, she was heading. Her daughter goes.
Yeah.
It's good to feel like national.
Well,
There's fewer schools.
her youngest. How much did you get from your book? One and a half. It's like, yeah.